Hi, I'm Amanda Bloomgren.
And I'm Katie Hanson, and we're the attorneys of Bloomgren Hanson Legal. And we're here today to talk to you about probate avoidance with real property, including joint tenancies, life estates, and transfer on death deeds.
I actually had an interesting situation recently with a client. Her husband had recently passed away, and they had previously owned some hunting land up north as joint tenants, and now she's the sole owner. She has two sons, and she's trying to decide whether or not to keep the property titled as is or do some probate avoidance, and she came to us to discuss the situation.
I can see her concern with probate, as it is the court process that's required for people to go through when they're the sole owner of a property. And it is can be a lengthy and complicated process that even with simple estates can be quite expensive. While you won't be going through it, your family will. And yet, like I said, with the simple estate, even it can, with few debts and one real property, it can cost upwards of $5,000.
So in order to try to avoid those costs, with this client, we initially discussed the option of a joint tenancy. A joint tenancy would be where two people, or here her three sons, would own the property jointly, and then the surviving party would end up being the one who could pass the property on to his or her heirs. Some of the concerns that I initially explored with respect to a joint tenancy surrounded the fact that she may want to sell the property in the future, and there's some concern about control. With a joint tenancy, she would actually have to have her sons sign off on any sale. If the sons were married, their wives would have to sign off, and that brings up the issue if the sons would ever end up getting a divorce. In a divorce situation, the property could actually get pulled into the dissolution proceedings, which can be a concern. That also brings up the issue of the sons with respect to any judgments or possible bankruptcy. If they were in either of those situations, the property actually could get pulled in to those proceedings and be subject to creditors, which is a concern.
Yeah. And another concern, kind of when you were talking about the definition of joint tenancies from an estate planning perspective, if it was in a joint tenancy, it would end up that the surviving son then would inherit the entire property and leave it to his heirs, whereas the son who passed away first would have nothing to give to his heirs.
Yeah, that's a real concern.
And then another thing to think about with joint tenancies is that in general, the tax treatment that's available with a joint tenancy is not as favorable as with the life estate or the transfer on death deed.
So because of those concerns, we also discussed the option of a life estate. A life estate is a probate avoidance vehicle that was used fairly regularly up until recently. In a life estate, the wife or the mom here would hold her interest in the property subject to her sons reserving an interest after she passed. One of the benefits similar to that takes care of an issue Katie raised with respect to the joint tenancy is that in that situation, in a life estate, she could title the property either her sons reserving a joint interest in the property or a tenancy in common, which would prevent one of the sons' heirs from not being able to receive the property. Unfortunately, some of the same concerns with respect to a joint tenancy still do exist, or excuse me, with a life estate still do exist. Those problems include the fact that if she wanted to transfer the property, the sons would still have to sign on, as with their wives, could get drug into a divorce proceeding. Also, some of the same concerns exist, maybe to a lesser extent, but still do exist if there was a judgment or a bankruptcy. One of the benefits of a life estate is that there is a little bit better of a tax treatment in most situations.
Yeah, and then, but with the transfer on death deed is a new vehicle that was allowed by the Minnesota legislature. They passed a statute that allows for the use of a transfer on death deed, which is a document that you execute and file with the county property records. And it allows for the passing of the property, the title to pass at the time of death. And as long as you follow the necessary statutory requirements and have it executed and filed, it allows you to transfer this as joint tenants or as tenants in common to whoever's written on the transfer on death deed, which allows, from an estate planning perspective, for the sons to each inherit half interest in the property. It also avoids some of those issues that you talked about with wanting to maintain sole control. With the transfer on death deed, it is revocable at any time. Even if it's been filed, you can revoke it. And if you sell the property, it automatically voids the transfer on death deed. Another thing with the transfer on death deed is that it, because the interest is not being passed until the time of the death of the grantor, then the son's creditors can't go after the property. They can't be brought into a bankruptcy proceeding or a divorce proceeding. And so those things can be avoided with a transfer on death deed. It also allows for a full step up in basis, so the tax treatment is a little bit more favorable with a transfer on death deed. One of the pitfalls that is still present is that it doesn't do anything to avoid medical assistance claims, although that's becoming harder and harder to do anyway.
So in the situation that we just described, the client did end up deciding to do a transfer on death deed. But it's important to note that Katie and I have had clients with all kinds of different situations where they've wanted to avoid probate with respect to a property and have decided to do a joint tenancy or a life estate or the transfer on death deed. So it really just depends on the facts of your situation. Because of this, it's really important, if you're deciding to transfer property to avoid probate, that you do talk to an attorney. It's important to talk to an attorney about your specific facts and apply those to each of the issues that we discussed today to determine the best course of action for your specific situation.
And here at Bloomgren Hanson Legal, we can service your needs in this area. Amanda practices in the area of real estate, and I practice in the area of estate planning and probate. So we're kind of full service in relation to these issues. Please visit us at www.bloomgrenhanson.com to find out more.